paragraph 3225 of the immigration rules. To assist those who wish to intervene or speak later on, I'm going to speak a bit about the background, recent case studies from my constituency, and then I have some questions for the Minister, if that helps you kind of tailor your remarks. I first want to begin by paying tribute to the members of the Highly Skilled Migrants Campaign Group, who have now held 4 large demonstrations outside this Parliament. They've also been extremely active in social media. They have self-organised and worked hard to give this issue the attention it deserves. And I'd also like to thank Amelia Hill at The Guardian and Kirstine Patterson at The National, who have provided first-rate coverage to this issue. To give some background, the Home Office has been, for at least over a year now, issuing highly skilled migrants, many of whom who entered the UK under the Tier 1 general route, with notices detailing that their leave to remain application has been refused. Many of these decisions, Ms McDonagh, it seems, have been predicated purely on applicants' alleged poor character in the wake of amendments to their tax returns and income statements. And in making these decisions, the Home Office has deemed highly skilled migrants as a threat to national security under paragraph 3225 of the immigration rules. And Ms McDonagh, that section reads, the undesirability of permitting the person concerned to remain in the United Kingdom in light of his conduct, including convictions which do not fall within paragraph 3221C, character or associations, or the fact that he represents a threat to national security. Ms McDonagh, this is highly inappropriate. It's important to note that section 3225 is discretionary. It should be for the Home Office to determine whether or not to use it based on the merits of each individual application. And it also places the burden of proof on applicants rather than on the Home Office. And what I have seen from my constituency casework and from listening to the stories of highly skilled migrants outside and those who have contacted me, is that this is regimented, calculated decision-making. Individuals are being refused wherever they have supplied details of different incomes or sought to amend information on a tax return, often on the instruction of an accountant. None of those whom I've spoken to have any issues which would cause them to be considered a threat to national security. And indeed, the very invoking of this clause and recording of it could compromise that person's future work and travel. What country, after all, would wish to accept somebody refused from the UK on such grounds? When applications are refused, it's incumbent on the applicant to challenge the decision through the courts. Many examples exist where the judge has overruled the decision of the Home Office, finding it entirely disproportionate. A number of individuals' refusals appear to be predicated on nothing more than the individual making an honest mistake. And as far as HMRC are concerned, when the correction has been made, the case is closed. Some of the sums involved in these corrections are only a few pounds, £1.20 and £1.60 in some cases have been reported. Some of the sums involved were many years ago, one of my own constituents from 2010. And many people have asked me the question, if there was a problem back then, why didn't it affect my status at that point? I raised this matter with the Financial Secretary to the Treasury at questions in May, and he confirmed that people should clearly continue to make appropriate changes to their tax returns, and further, that Treasury Ministers and HMRC officials are working closely across government, particularly within the Home Office, on the issues that I raised in order to ensure that we get these matters right.
You've done a really good way.
Of course. Yep.
First of all, congratulate the Honourable Lady on bringing this forward to Westminster Hall for consideration. Does Honourable Lady not agree that some of those who have been affected are doctors, highly skilled people, highly valued members of our medical society, for example, in the Ulster Hospital in Northern Ireland, and indeed in hospitals throughout the United Kingdom, Great Britain and Northern Ireland? We must ensure that those who are actually living and working and pouring into and making a difference in their communities, as they are able to continue without undue stress of overly onerous immigration procedures due to simple, non-criminal mistakes on tax returns that perhaps maybe some in this House have even made themselves.
The Honourable Member is absolutely correct. And many of these people that I've spoken to are people that are in shortage occupations and are very much valued, the very people that we would wish to attract to this country to come and work. Of course.
And just like her, several highly skilled migrants in my Slough constituency have had Home Office applications refused due to the heavy-handed application of paragraph 3225. Of those contacting me, many have lived in the UK for over a decade and have British-born children and are now in an absolute state of despair. Ms McDonagh, one told me, I have given my best years and contribute to the growth of Britain. My private family and professional life are established here. I am a law-abiding citizen and have never faced criminal charges of any kind. Does my honourable friend agree with me that it's very difficult to respond to somebody in such circumstances, and indeed that this hostile environment of this Tory government needs to end?
I absolutely agree with my honourable friend, and it chimes with many of the stories I have heard too, and particularly the impact on children, because they don't know why all of a sudden their parents aren't allowed to work. and some of them have not been able to access medical care for their children as well, which is deeply worrying. Of course.
Similarly, for giving way, and she will be aware of a case of my constituent who was an individual who had this rule applied to him, but actually, in many ways, the biggest impact was on his wife, who NH Scotland removed access to any medical services for, even though she was 8 months pregnant. And whilst it is completely the case that NHS Scotland and indeed Home Office staff have very difficult jobs in very high stressful situations, when mistakes are made, they can have really serious consequences which are very hard to unpick.
I thank you very much for that intervention, and I have a cause to meet him, his constituent as well, and is deeply concerned about that. I am so concerned that I have written to the Secretary of State for Health in Scotland to ensure that all GP practices in Scotland understand that they can't just book people off their lists in these circumstances, and certainly women who are 8 months pregnant need medical care and should not lose it due to the errors of the Home Office. If you give me a wee bit to make a wee bit of progress, I would appreciate it. It seems extremely odd to me that the HMRC could be satisfied, but the Home Office should treat that same behaviour as being akin to deception at the least and terrorism at the worst. If the Minister and I, as the Honourable gentleman from Strangford mentioned, or anybody else in this room, made a legitimate in-time correction to our tax return, the consequences would not be that our lives would be turned upside down, that a threat of removal would be placed over our heads. It's said that 500,000 British citizens amend their tax records every year within the 1 year grace period the HMRC allows. And others, of course, will do it outside of that time period. None of these people, Ms McDonough, will be served under 3225 or treated as criminals. The only reason that highly skilled migrants are being treated in this way is because of their nationality. And as far as I'm concerned, that is discrimination under Article 8. In one case that was reported to the press, an individual who came to the UK via the Tier 1 route went through this process. He presented a letter from his accountant detailing the error was the fault of the accountant, as well as a letter from HMRC explaining that they were satisfied that the individual was not in any way acting dishonestly, but the Home Office refused to exercise any discretion or change its original decision. In another case, an individual found that his tax information, after it had been scrutinised by 3 different appeal courts, found no evidence of irregularities whatsoever. And the individual's lawyer noted that the Home Office had made a basic accounting error in comparing the client's gross income to his net income.
Well, have you worked?
Of course.
I'm grateful for her giving way. She's making an excellent speech. Isn't that one of the key points? The Home Office officials don't know anything about tax, and they're making decisions about people's lives on tax. This has to be taken away from them today.
I absolutely agree with his point, and it is the QC Paul Garlick, who specialises in extradition and human rights law, said of this that the system's crippled by not having enough people to do the work, while those who are there don't understand the basics, as he very much says. They genuinely have no idea of the difference between tax years and accounting years, or what is a legitimately deductible expense. He goes on to say, my feeling is that since Theresa May's announcement of the hostile environment for immigrants, caseworkers have been told to look for discrepancies that could form the basis of an accusation that the applicant is lying, because that is the quickest way to dispose of an application. Of course.
Thank the Honourable Lady for giving way. She's making an excellent case. Is it not true that HMRC have wide-ranging powers and where they can prosecute where there's any whiff of criminality? And in none of these cases have they taken that route, because this is a mistake or it's just a genuine small error like many of us have made.
She's absolutely right. If there was a case to answer, HMRC would have something to say about it. That is beyond doubt. And the impact is also wider than the individuals involved. And I spoke last week to Salim Dadaboy, who employs 20 people in his business. And all of those people would be made unemployed and a British company worth £1.5 million wound up if this situation is not resolved. Ms McDonough, this is economic madness, and the Home Office should carefully consider the impact of their target-driven culture on the economy, especially in these uncertain times. And I've spoken to many highly skilled migrants, all of whom have been distressed at the way they've been treated, having given the best years of their lives to the UK and made their home here. We should be thanking this group, Ms McDonough, not putting them out. My constituent, Omar Khattab, travelled to the UK on a study visa in 2006, completed a Masters in International Marketing at University of the West of Scotland in 2009, and has since worked in journalism and marketing before starting up his own business. His accountant completed his tax return on his behalf, and the errors that the accountant inadvertently made were rectified by my constituents months later. Omar has written documents from his accountant proving this and accepting full responsibility for those errors. Now, Omar also suffers from depression and anxiety, a factor that his GP and psychiatrists have acknowledged that would undoubtedly contribute to his inability to spot an administrative error in his tax return. And his stress has only worsened due to the ongoing nature of his case. And he has said, I feel this is my home. I thought my children will grow up here, that I will get married and die here. That letter saying I don't belong to this place, I'm a threat to national security, it's very hard to swallow. Ms McDonagh, it's hard for all of us to swallow.
Will the honourable member give way?
Of course.
I'm grateful to the honourable member. Does she not agree with me that as it is a sort of terrorism-associated provision, this paragraph, the implications are very wide-ranging. It leaves a black mark on these people's lives forever, and it means that it's very difficult for them to ever get a visa or work anywhere worldwide after all this.
Absolutely, and that's why there needs to be a proper, thorough inquiry into the use of this clause, because if Home Office staff are being advised to go and use this as a means of refusing people, they are quite clearly not looking at the full implications of this and the long-term impact it could have. Now, for my constituent, Omar, he was refused leave to remain on the basis that he deceived the department, which goes entirely against all the evidence that he's provided. HMRC have written to him to say that they are satisfied that he's acted honestly, that he's not tried to deceive anyone. Mustafa Ali Beg also travelled to the UK to study in 2006. He obtained a master's degree in international marketing from the University of the West of Scotland in 2009. And Mustafa and Omar, they have a lovely picture of the two of them after they graduated. These two young boys with all their lives ahead of them. And Omar certainly is almost unrecognisable from that picture, from the stress that he has been under due to this. So since coming to the UK, Previous to coming to the UK, Mustafa obtained a Bachelor of Law degree at the University of Punjab. He has a Master's degree in political science, and he's worked in business development, marketing and public relations. He's undertaken voluntary positions for civil rights and social action groups. He also volunteers to run a current affairs radio show and is very much part of the Glasgow community and has gone above and beyond to advocate for his friends. As far as I'm aware, Ms McDonagh, there is no question over his integrity. But due to this rule, as the honourable member just pointed out, he's now being told that he's of questionable character, that he's a threat to national security as a result of correcting a small error on his tax return in 2010. There is no basis in which to remove somebody in this way. His case goes to the Immigration Tribunal on the 20th of July, and this proves the 20th of June, rather, and this proves that the decisions on these cases are still being made, despite what the Home Secretary has said. Mr Sanjeev Pandey travelled to the UK in 2005 on a student visa and graduated from Glasgow University in 2008. He started his own IT business and was also employed as an IT consultant and project manager, a very lucrative career, Ms McDonagh. Most recently, he'd been leading an IT project for a bank in Scotland before his right to work was removed by the Home Office. He had applied for ILR under long-term residency rules in 2017. He's been in the UK for 12 years at this point. He hired an accountant, but in the tax return submissions were subsequently questioned by the Home Office. Now, Mr Pandey made attempts to change his accountants as a result of this, to rectify the errors, but the Home Office have continued to pursue him on the basis that they believed him to be dishonest. Now, most distressingly, Mr Pandey was detained at Heathrow Airport following return from a family holiday in 2017, with his passport and BRP confiscated from immigration officers, removing his right to work. This has had a huge impact on the family's finances, Ms McDonagh, as he has a mortgage and other commitments. Now, judges found in his favour both the upper-tier and first-tier tribunals, and the paperwork from the first-tier tribunal states this in some detail. I'll read it out. It's a long quote, but I think it's worth putting this on the record. The judge at the first-tier tribunal said, "The refusal letter, I think, is confusing itself in relation to the appellant's income, but I have to say that I found both the appellant and his wife to be credible witnesses. I do not think that they have acted dishonestly. The appellant relied on the advice of an accountant. He was entitled to rely on that advice, and while he is under a duty to check information, it's entirely unfair to expect him to have a level of accountancy and tax knowledge accorded to professionals in this field. He was clear, he sought clarification from the accountant, but eventually, when he was unable to get satisfactory answers, he's changed his accountant. It also appears to me that the appellant was unfairly treated by the Home Office. His passport was retained during the first appeal proceedings. As a result, he was unable to find employment, since employers refused to employ him without the benefits of having his passport. He was, I think, therefore prejudiced, and I consider that this matter should be taken into account in the question of proportionality. Taking all of the above into account, therefore, I do not consider that the appellant has acted dishonestly. He may have been misguided, but that's a different matter, and I consider that it would be disproportionate in the circumstances to expect the appellant and his wife to leave the UK, particularly as they own property in the UK, they pay tax in the UK, and they've spent a considerable number of years here. Lastly, I want to highlight the case of a female constituent. I don't want to name her because her children are at school in my constituency. And she travelled to the UK from Nigeria and was refused leave to remain in the same circumstances under 3225. She legitimately made changes to a tax return, and the Home Office is similarly putting forward an argument that she tried to deceive the department and have refused her an administrative review. My constituent is actually a qualified accountant and has been able to continue seeking work in her field as a result of her status imposed by the Home Office. She has been made destitute as she has no recourse to public funds, as many under the Tier 1 route have no recourse to public funds. And she's been to my office to seek help in getting school uniforms for her children. Without being able to work, she's struggling to keep her family afloat, and there's a very real risk that she will be made homeless as a result of the Home Office decision with her children as well. Her landlord, the Wheatley Group, confirmed just yesterday that due to the support of her church paying her rent, they are not proceeding with legal action to evict her at this point, but that option very much remains open. I'm extremely grateful to the Wheatley Group for the discretion that they have made, but Ms McDonagh, this situation is not sustainable. My constituent needs to get back to work. This issue has all been considered by the Home Affairs Select Committee, and the Home Secretary has entered into correspondence with the Chair, committing that all 3225 applications will be put on hold and a review carried out by the end of May. Ms McDonagh, as far as I can ascertain, that review has not yet been published and no further detail is available on that review. And as I mentioned with my constituent Mustafa, decisions are being still made. I'm happy to take this intervention.
Congratulate on this debate and apologise. I missed the first few minutes due to the business in the chamber. She's absolutely right that we're still not clear on the Home Affairs Committee on which I sit where the government is going on this matter. And would she agree with me that actually what this scandal shows is that there's a wider systemic problem in the department, as we've seen through Windrush, through this, and a series of decisions being made wrongly, that when you have hostile environment, lack of discretion, cuts in staff, cuts in ability, and ministers who quite frankly don't have a grip of what's going on in their department, the net result is damage to individuals and their families.
Yeah. I absolutely agree, and it's quite worrying that even the Home Affairs Select Committee can't get certain answers on these things, because it is of huge concern, and these decisions are clearly, from the people that I spoke to at the Highly Skilled Migrants demo last week, decisions are still being made. They are clear upon that.
I'm very grateful indeed to the Honourable Lady for giving way. She's being very generous and she's making a very, very powerful speech. Does she not agree that the Home Office was made aware of these issues in letters from myself and others around this room right back in mid-March, and no action was taken at that stage? And it's just not good enough to have this delay in action when it's affecting people's lives in such a terrible manner.
Yes, I would absolutely agree with her. And the constituents that have been to me, I've been trying to get answers for some months as well. The woman I mentioned came to see me in January, and she has still not yet got answers on her case. And it's not always evident when constituents come to us that they are affected under these particular rules as well. You often have to see a refusal letter to understand exactly why the refusal has been made. So there have been growing numbers of people getting in touch with me to say that this has been their circumstance. And all of them who have not been my own constituents, I've encouraged to get in touch with their MPs as well, and I'm sure they have done with a number of people in the room here today. Ms McDonagh, to add insult to injury, the Times reported this morning that a new visa route for migrants who want to start businesses in the UK is to be expanded to include non-graduates under efforts to increase technological innovation. Ms McDonagh, this is rank hypocrisy. How can the UK government reasonably expect to attract new migrants to the country when it treats the highly skilled population who are already here and have been for years with such utter disrespect? Ms McDonagh, I have a number of questions which I hope the Minister can assist with. When will the review that was mentioned be published? How many cases are in progress? And how many are awaiting judicial review? I had asked the Home Office how many people had been refused under this, and I understand that Channel 4 News also put in an FOI to the department without getting any adequate response. Was an instruction issued to start refusing cases under this rule, and if so, by whom and when? The Telegraph reported on the 2nd of May that Home Office caseworkers had discussed using previous amendments to tax returns to cast doubt on current tax returns. Could she tell me how widespread this practice is? Can she allow people caught up in all of this the right to work, the right to access NHS services and the right to rent during these appeals? Because they often lose these as soon as the administration review is refused, which is the first line of appeal after the initial refusal. And as was mentioned by the Honourable Member for East Renfrewshire, this has a serious impact particularly on women who may be pregnant. Can she tell me, will there be compensation to offer to those wrongly caught up in this mess, just like Windrush? People affected can be out tens of thousands of pounds, particularly if they cannot get legal aid for their cases, and because they have not been able to work and have gone into debt and arrears. And lastly, what does the Minister have to say about the impact of this policy on individuals? I've been told by many about the strain on their mental health, on their relationships, both here with their family and with relatives abroad who they are not able to go and visit. The stress of having to report to the Home Office regularly, sometimes on a fortnightly basis, and the loss of employment. And is there a wider economic impact of this policy? Ms McDonough, the Home Office's policy of deliberately targeting these highly skilled migrants is yet another example of this cruel Tory government's hostile environment policy in action. The group being targeted here are highly skilled. They are doctors, they are accountants, they are IT professionals, they are teachers and academics, to name only a few. And they have put down roots and contributed greatly to their communities. The UK Government continue to talk about attracting talent, yet their behaviour towards this group show that they clearly aren't interested in retaining much of the highly skilled population that's already here, who are already well integrated and contributing hugely. I urge the Minister to take swift action now to support the highly skilled migrants who have done us the honour of choosing to live here.
All right. Can I just say, as everybody will be aware, that this is a very popular debate and people have done really well at getting their MPs here. There are 8 people who wish to speak in the 20 minutes left. So I'm really sorry. If we're going to get everybody in, it's 2.5 minutes. Sorry, Douglas Ross.
Well, thank you very much, and I'll scrap most of what I have in front of me then, but can I thank you, Ms McDonough, it's a pleasure to serve under your chairmanship, and can I genuinely congratulate the Honourable Lady for Glasgow Central for securing this debate, because I think it's important that we do discuss this, and I'm also extremely grateful as a member of the Home Affairs Select Committee to have had the privilege to meet with some of the campaigners and some of the people affected by this earlier on today, because it allowed us, I believe, as members of the committee to hear some of the real true hardships that are being faced by a number of people because these immigration rules, which are there for a reason, are perhaps not being implemented in as useful and as credible a way as possible. I just want to briefly mention a couple of things. We heard this morning that no fewer than 1,000 highly skilled immigrants are facing expulsion from this country under this particular paragraph, and that is not correct. The Honourable Lady from Glasgow Central mentioned the 2 individuals who owed HMRC £1.20 and £1.60. We heard these were brothers, and that is their only offence against HMRC is to owe £1.20 and £1.60, yet this rule is being used by the Home Office to potentially remove them from this country. It seems that either a simple mistake or no mistake at all leads to a law-abiding immigrant's application being refused out of hand. Therefore, that means there is no common sense being used. And I was going to, at this point, read from the letter to the Home Affairs Select Committee from the Home Secretary, but the Honourable Lady from Glasgow Central did that. However, he did say in that letter, and I would urge the Minister to answer this point, that the Immigration Minister or he would report back to the Home Affairs Select Committee by the end of May. We're now on the 13th of June, and I checked with the clerk at the start of this meeting, and despite chasing up the Home Office's parliamentary officials this afternoon, we as a committee still have no knowledge of the Home Secretary or the Immigration Minister's response to that, and we really need that as quickly as possible. Because I genuinely believe, and I asked this question of our guests this morning, because I didn't want to put words into their mouth. I asked them, is it the policy that's wrong or the implementation? And I believe they agreed that the policy is right. We are right to have these anti-terror policies, but it is the way it is being implemented. And what I would hope is that the Immigration Minister can go from this debate and give the caseworkers more clarification on how to use this policy the way it's intended, not to inflict suffering on people who should not be affected by it. Thank you.
Lynn Brown.
Thank you, Ms McDonough. Can I say, I want to tell you about 2 of my constituents. Mohammed lived and contributed to the UK for 11 years, Masters in Architecture from Oxford Brookes. His wife's pregnant, he's got a career, a home, a mortgage, a real life in the UK. And the Home Office refused him indefinite leave on the basis of a minor tax error. Error wasn't his. Mohammed is dyslexic, doesn't do his own tax returns, submitted by a professional accountant who made the mistake, who issued an apology, and Mohammed immediately paid every single penny owed once the mistake was discovered. Last year, Mohammed's grandmother died in April, his only brother. Couldn't go to the funerals because he wouldn't be allowed back in the country afterwards. Baby's expected in September, and he's been invoiced by the NHS for £9,000. And if he doesn't pay that £9,000, then his wife comes off the GP list if he fails to pay. Mohammed's case is not singular, far from it. Sadiq, a senior lecturer at a university in the UK. Before he was at the University of Derby, he's been in the UK, living and working for 7 years. Sadiq applied for indefinite leave in 2016 and the Home Office refused it because 2011 he made and accepted a minor error on his tax return. Repaid same year, hardly a mark of bad character. He's suspended from his job. He'll soon be forced to withdraw from his part-time masters at the University of Oxford. He volunteers with Amnesty International, Save the Children, UNICEF. He promotes IT skills within the Bangladesh community. Graduate of the Year at the University of Bedfordshire in 2011, 2012, 2013. Finalist at the British Computer Society, of which he is now a fellow. In fact, he's a fellow of the Royal Society of Arts. Sadiq's wife and daughter have already left the UK. Second daughter born in Bangladesh, but Sadiq has never met her. Why? Because he can't go, because if he did, he wouldn't be allowed to return. Bangladesh, Sadiq was the dean of a university faculty, so why won't he just leave when he's been so badly and disgustedly treated by our government? Well, that's basically what he plans to do. He's been worn down, and despite pending judicial review, he is just going. It's hard to look at cases like Mohammed, like Sadiq, like Windrush, and not conclude that this government is chasing an arbitrary immigration target, regardless of the needs of our economy, or indeed the NHS, or any sense of decency we might still have left as a country. Frankly, the government's got to look at its reputational damage on this issue.
Jess Phillips.
Thank you, I, like everybody, have constituency cases in this matter. My constituent, Inam Raziq, has been fighting this for what has taken many, many years off his life, it would seem, but also £80,000 of his money. He is among the people who helped organise the hundreds and hundreds of case studies that have gone today to the Home Affairs Select Committee that were spoken about today. I, in fact, sent those case studies, 300 case studies, to the Home Affairs Select Committee and to the Home Office in November last year, and in the 7 months since that occurred, the Home Office have still failed to do anything about this issue of, which is basically, if we're honest, it's just another issue of low-hanging fruit. Who are the people we can get rid of quickest on a target-driven culture? So I had written to the ministers about this issue in November, telling them of all the hundreds of case studies that were going on, including the very specific case about my constituent Inam, and still, when questioned about it, the Home Office says, oh, we didn't know about it. Well, then, I mean, I don't write the most amazing emails, I'll grant you, but I did tell you. Not you, Miss McDonough. You, no doubt, would have listened. I also just want to, because I've got a minute left, I just wonder if the Minister would answer for me if she feels that these were good and honest mistakes, because in here we're allowed to make good and honest mistakes. The Health Secretary made a good and honest mistake when he forgot that he owned some luxury flats, which I'm sure everyone along here could agree. We could all forget the owning of luxury flats. I mean, I'm sure I've got many that I've forgotten. And he forgot to declare them to this place. He forgot to declare them to the I can't even remember where it was. The Company's House, that's right. He forgot to declare them to Company's House. And that was considered an honest mistake. Inam Raziq is an honest man. I shall leave the judgment of the Health Secretary for everyone else in here.
Faisal Rashid.
Thank you, Mr. It is estimated that thousands of migrants who have been living and working in the UK for many years are wrongfully facing deportation because of minor tax discrepancies or rectifications. The immigration rules we are discussing today, paragraph 322(5), are extremely vague. Fortunately, the Home Office issued guidance on when to use this subparagraph to deny leave to remain. It states that The main types of cases you need to consider for refusal under paragraph 322(5) are those that involve criminality, a threat to national security, war crimes, or travel bans. Honourable members, let's be clear, we are all here today because the people being denied leave to remain under this paragraph are none of the above. They are doctors, lawyers, engineers, IT technicians, and other highly skilled migrants who provide a valuable contribution to our country. One of them is my constituent who has lived in this country for almost 10 years. He works in the IT sector, has one son, was born in this country, and his wife is expecting their second child. Now he is being punished because he made a minor tax rectification which HMRC accepted prior to applying for indefinite leave to remain, and even notified to UKVI of the change. Because of this minor change, his application has been on hold for over 2 years, and he is anxious and concerned that he, like many others, will be forced to leave the country that has been home for him and his young family for the last 10 years. My constituent works hard, pays his taxes, provides for his family, and contributes to his community. His future and the future of hundreds of others in his position should not be left in limbo because he did the right thing and corrected his tax returns. My constituent and his family are living with stress, anxiety, and uncertainty, which is not acceptable. It does not take a review to recognize that something is wrong here. Ordinary people who contribute to our economy are being denied leave to remain because of routine changes or simple mistakes. My two questions are these wrongful deportations a result of pressure from the government to meet deportation targets, or is it government's typical defense to be believed that this is merely a result of the government's reckless incompetencies?
Steve Reid.
I congratulate the Honourable Lady for calling this important debate. I just want to focus on one constituent of mine because I think it's the individual cases that really highlight the damage that the government is doing. I have a constituent who is a woman. She prefers to remain anonymous, but she came here from Zimbabwe in 2007 after winning a British Council scholarship to Birkbeck College in London, and she's been a model citizen ever since. She works very hard. She's never had fewer than 2 jobs at any one time. She's bringing up her 3 children without any recourse to public funds. She's held management jobs. She's the director of a company she set up herself in 2010. She's been a governor and a volunteer as a school in her community. She's run 3 marathons for charity, and she volunteers at Crisis at Christmas, and she helped to set up an arthritis charity. Now, this woman suffered the horrific experience in 2010 of being raped, and her attacker was eventually sentenced to 15 years in prison. In the aftermath of that trauma, she made a mistake on her tax return, and she put that down to the many pressures on her life at that time. And when you consider she was dealing with a serious sexual assault, holding down multiple jobs, volunteering and bringing up 3 children, she had an awful lot on her plate. She realised the mistake herself, she reported it to HMRC, she put her affairs in order, and she paid off the underpayment. HMRC accepted that it was a mistake, and they didn't impose a fine because of that. A few months later, she applied for indefinite leave to remain, but after a 19-month wait from the Home Office, she was rejected on the grounds of a tax discrepancy that had already been resolved to the satisfaction of HMRC. This woman has now used up all of her life savings on legal advice, has lost the right to work, she can no longer afford to pay her mortgage or her bills, and she's forced to live on handouts while she faces immediate deportation unless she can raise enough money to carry out further legal action. The government has ruined this woman's life. Now, clearly this woman and thousands other like her are assets to this country. They must not be used as pawns in the government's attempts to cover up the failures of their immigration policy by targeting people whose presence in this country is wholly legitimate and wholly beneficial. I hope the Minister will now agree to suspend the use of this clause for purposes it was never intended for, that she will set up a hardship fund to help people who this policy has damaged, that she will offer compensation to people who have lost their jobs, homes, savings and livelihoods because of it, and I hope she will say sorry to the people she's damaged.
Stephen Timms.
Thank you,
Ms McDonagh. I want also to congratulate the Honourable Member for Glasgow Central on all her work on this and for her speech this afternoon. I've got a large group of constituents affected exactly in the way that others are. But what I wanted to say is this. I was a minister with tax responsibilities on 4 separate occasions. And it is an important principle of our tax system that once a mistake has been identified and any additional tax due has been paid, the authorities don't come back with further recriminations unless new information comes to light subsequently. And it has to be like that, because otherwise there isn't an incentive for people to own up to mistakes and to pay the additional tax due. And in cases we're talking about this afternoon, people have owned up to mistakes, tax has been paid, HMRC has been completely satisfied, but the Home Office is coming back sometimes years later with recriminations, not just demanding more money, but destroying people's livelihoods, in a number of cases breaking up families in a way that is wholly wrong and unfair. I'm certainly, like others, meeting a large number of people in this situation. My honourable friend referred earlier to the case of the Health Secretary, who failed to do what he should have done, and, as she said, described it as an honest administrative mistake, and there was no sanction taken against him. Now, I don't complain about the fact there wasn't a sanction, but what we cannot have is an arrangement where there is one rule for cabinet ministers and affluent people and a completely different rule for our constituents. That is not the way things are done in Britain, and it is not the way the Home Office can be allowed to behave. People's lives are literally being destroyed because they made honest administrative mistakes, which have long since been rectified. And for far too many, the Home Office's hostile environment has become an oppressive nightmare. This must end, and we need the Minister to take action today to start to put things right.
Steve McCabe.
Thank you, Ms McDonagh. I also congratulate the Honourable Lady. I'm going to concentrate on one case as well. Mr Iftikhar Ahmad, a constituent of mine. There are many others. He's been running a business in this country, actually employing other people since 2011. He's also a victim of the Prime Minister's hostile environment. I don't know what it says about the state of our country when you end up with a provision that was designed to protect us from terrorism being used to pick on people for a minor tax difficulty, but it doesn't make us sound the sort of place that anybody would particularly want to live. To me, now, what the Minister must know perfectly well is whenever MPs raise this, the replies they get are wholly inadequate. Yep. They get a cut-and-paste letter that tells you nobody's bothered to read it. It's got a standard stamp on it, and there's absolutely no prospect of telling you when this matter might be dealt with. Now, I don't blame the Minister for the hostile environment. I think the Prime Minister created that state of affairs when she was at the Home Office. And I do know that actually since this got a bit of attention in the press, the government have now announced it's no longer government policy, which I'm delighted to hear. So I'm wondering, even with the limited time, if the Minister today will tell us honestly what happened. She's the Minister left holding the baby now. What did happen? How did we end up in this state of affairs? And will she give us a clue as to what she thinks the numbers are? I certainly have reason to believe it's well over 1,000. We know from Windrush it started small and suddenly we discovered it was a much bigger figure. How many families, how many lives like the ones we've heard about already are being wrecked as a result of this situation? And what is she going to do for people like Mr Ahmad, his wife and his 3 children? Because he can't provide for them anymore, just like everybody else. He's almost spent up on his life savings he accumulated through his hard work in this country while he was paying taxes and helping the rest of us. He's almost spent up. Is she going to give him a chance to work while this review is being concluded?
Thank you, Ms McDonough, and it's a pleasure to serve under you. I'd also like to thank the Honourable Member for Glasgow Central for bringing this excellent debate. I will try not to repeat the points she and others have made. I need to declare an interest that I was Chair of Barrow Cadbury Trust that funded the Migrants' Rights Network from its inception, and it was the MRN who has been part of the group of organisations supporting this work in Parliament today and at other times. On Friday, I met a group of constituents in my surgery, individuals and couples affected by the new operation of the immigration regulations. They're all from India, highly qualified, well-paid, well-respected IT professionals. They came to answer this country's skill shortage, a skill shortage that has not gone away. They work in our large and reputable companies such as Sky, Royal Mail, and one they know even works for the HMRC. Today, the government launched a programme to attract tech entrepreneurs to the UK, yet the Home Office is effectively sending home high-skilled tech people who contribute so much to our economy, and I have to say are also, of course, net contributors to the Exchequer. Ms McDonough, I feel that after the Windrush scandal, this is yet another example of the hostile environment now operating in the Home Office. Many have been refused for spurious reasons. For those without the right of appeal, it means they can't work, can't take up the offer of promotion, they can't rent a flat, they may lose their driving licence. And even those with pending appeals or JR applications who can work are losing jobs because nervous employers have asked them to resign. Many can't travel to see family, and they can't explain to their family why they can't go and visit. One I met was told by the Home Office he could get his travel documents if to attend his brother's funeral if he withdrew his application. Given their age profile, many have small children or they want to start a family, but they can't when they're in this limbo. What they told me, they said, we love this country, we don't want to leave, yet we feel we're just numbers. And then they said, you, people like me, you want to attract the talent from across the world, yet you don't respect us who are here. Not me, but this government and what they feel this country. This is affecting, they said, this is affecting the reputation of the UK around the world. Not just refused because of tax problems, but also people who, with their employer's permission, extend their leave beyond the normal 28 days to 45 days, or for maternity leave, refused.
Could I start as well by thanking my honourable friend for securing this debate and for pursuing this issue indeed with her usual determination and eloquence, not just today but over several weeks. Can I thank all honourable members for their contributions, and as Honourable Member for Murray did, thank the campaigners and the witnesses who spoke with us this morning to give us a real insight into what is going on, because I do not think there is a more effective way to highlight yet another rotten Home Office stink than by relaying the personal stories of individuals affected, as honourable members rightly did today. I started jotting them down. The Honourable Member for Strangford spoke about doctors who'd made simple mistakes with their tax returns. The Honourable Member for Slough about people who'd been here for a decade with families and were law-abiding citizens. But I stopped when I got to the gob-smacking story relayed by the Honourable Member for West Ham about the accountant who had owned up, and yet that still wasn't enough to satisfy the Home Office and all the consequences that followed from that. All of this reeks of another episode of the Home Office coming up with a new wheeze to increase the number of people they can remove, and then they implement it with no concern for whether decisions stand up to scrutiny in terms of the law or indeed basic common decency. It's clear the Home Office did not like Tier 1 General. They closed it to new applicants in December 2010, and those who are still in that process are facing severe repercussions. Low-hanging fruit indeed. So can the Minister, in her response, tell us, has there been any change to any of the Home Office guidance? Have there been any new policies or instructions issued which relate to tax discrepancies and the relevance of Rule 3225 to that issue? And if not, what is her explanation for this sudden upsurge in the number of cases that we've seen over the last 12 months? Because members today have rightly pointed out, and we were told this morning, that there are now probably over 1,000 cases. Can she confirm the numbers that her department has? What does the data on appeals and judicial reviews tell us? And what has happened to the review we were told was due to be completed by the end of May? And going further, why has the department been so slow, given that honourable members, such as Honourable Member for Oxford East or Birmingham Yardley, or indeed my honourable friend, have been raising this for months? Once again, it seems there are systemic issues in the Home Office and that those at the top do not appear to know what is going on. When did the practice of comparing declared income on Home Office applications with tax returns commence, and what safeguards are put in place to ensure that caseworkers, who are not accountants and are not tax lawyers, didn't put 2 and 2 together and come up with 4, because that is exactly what seems to be happening in too many cases. We've all read about the cases where minor errors were corrected without demur from HMRC, where the sums were declared were different purely as a result of accounting periods or different rules applying, and we've heard again about the cases where the differences were £1.20 or £1.60. When was it decided that this particular rule was remotely appropriate for the sorts of circumstances that we've heard about today? A rule which a Home Office guidance states is usually to be focused on people involved in serious crime, threats to national security, war crimes and travel bans. As the Honourable Friend said, and indeed the Honourable Member for Ealing Central, that could have serious implications for applications to travel to other countries. And the Minister will no doubt, as she has done before, flag up examples where there has apparently been genuine fraud. Obviously, she cannot publish the details of those cases, and that is understood. But the problems with that being the total response from the Home Office are twofold. First of all, it's utterly contrary to the experience of everybody in this room, as has been relayed today. And it seems yet again that the Home Office is using the example of a few bad eggs as an excuse to throw out over 1,000 people, essentially. And secondly, it's a question of trust, because I do not think many members of the public or MPs here today, especially after Windrush, are really going to be happy with the Home Office turning around and saying, trust us, we're going to review things and we're going to sort it out. If the Minister wants us to have confidence again in the process, there has to be an independent review of what's going on, and ask her whether she will set that up. Finally, and most crucially of all, what steps can be taken to allow those individuals to live their lives here while they challenge what appear in many cases to be absolutely perverse decisions? Individuals and families are facing destitution and bankruptcy because of the outrageous changes to appeal rights made in 2014 and 2016. If the immigration system was just and respected the rule of law, all of them would have an in-country right of appeal to the tribunal, and their leave to remain would automatically extend so that they could still work until their appeal process had been completed. So what's the Minister going to do about that? And let me just finish by repeating what my honourable friend has said. So many of those involved in this are people we should be thanking, not threatening with removal. If there's one positive from today, Ms McDonagh, it's that they know that MPs across the political divide are on their side and are determined to put that right, and I very much hope the Minister is listening.
So Khan.
Thank you, Chair. It's an honour to serve under you, and can I also thank the member for securing this debate and all the members actually for their contribution. The government's treatment of highly skilled migrants has been shocking and unfair. Highly skilled migrants who have made legitimate and lawful changes to their tax returns are being put in the same category as serious criminals and terrorists. This is not just about the treatment of highly skilled migrants. This is about a hostile environment created by this government that treats all migrants like criminals and cannot distinguish between legals and illegal migrants. And it is about an ineffective department that makes absurd mistakes, refuses appeals, and cannot pick up on casework trends without media outrage. First, I would like to discuss paragraph 3225 and the way it is being used. According to the Home Office policy guidance, this paragraph should be used for cases of criminality, threat to national security, war crimes, or travel bans. Yet a large number of refusals are on the basis of minor tax errors, many of which individuals have picked up on and corrected themselves as is their right. The government's overbearing, hostile environment treats all migrants like criminals. Does the Minister recognise that many people are being penalised on the basis of 3225 because of mistakes by the Home Office? According to the Home Office guidance, UKV1, case workers are instructed to refer potential refusal decisions under 3225 to a senior caseworker. Given the mistakes that I and other honourable members have mentioned, does she think this system is working? How can such basic errors get past senior caseworkers and be allowed to play havoc with people's lives in this way? These are the actions of an overbearing Home Office driven by the Tory targets of reducing net migration and failing to treat applicants in a fair and reasonable way. At least 1,000 highly skilled migrants seeking indefinite leave to remain are wrongly facing deportation because of this paragraph. There are thousands of these kind of people. Our country desperately needs NHS doctors, lawyers, teachers, engineers. The effect of a refusal on these cases is devastating and lasting. People becoming ineligible to another visa and are banned from returning to the UK for 10 years. Often people are either given only 14 days to leave the country, or if they stay, they are refused the right to work, rent, or access NHS services. This is all without mentioning the mental and emotional effect of this process. During Home Office question last week, I raised the issue of highly skilled migrants with the Minister. The Minister said there have been several instances where those minor discrepancies have run into tens of thousands of pounds, and went on to say, we want to make sure that we collect the amount of tax that is owing. Of course, nobody here would disagree that we want to collect taxes that is owed. I would, however, refer to 2 points. First is the HMS interest for people to collect their taxes, and HMRC is explicit that this is entirely permissible and encouraged if done within 12 months time framework. And is she comfortable that the role the Home Office is taking on, double-guessing HMRC decisions and reassessing cases that they have said are settled and not be penalized? Can I just, in conclusion, say this, Chair? Many cases of highly skilled migrants are heartbreaking, not to mention nonsensical for the perspective of the UK's interest. Our NHS is facing a staffing crisis. Our business needs skills. Yet the Home Office is denying visas to NHS doctors, lawyers, teachers, and engineers, condemning them to be labelled as terrorists, criminals, and a threat to national security when they have committed only minor tax errors. Will the Minister commit to applying paragraph 3225 properly to target serious criminals and not bad accountants? Will she tell her officials not to automatically deny visas when they spot minor mistakes? And will she recognize that minor mistakes in tax returns are not evidence of fraud? The reckless, hostile environment is targeting the wrong people.
Thank you, Ms McDonough, and can I start by saying it's a pleasure, as always, to serve under your chairmanship. And I'd like to congratulate the Honourable Member for Glasgow Central for securing this exceptionally well-attended debate this afternoon. There have been numerous contributions from members, and I fear I won't have enough time to do them justice by referencing them individually. But I do think, and that is one of the reasons why we have the review, that it is important that we look very closely at this whole matter. The Honourable Lady and many honourable members have raised individual cases, and they are, of course, central to this debate. But we must also reflect on the policy as a whole, indeed, as many members have requested that I do this afternoon. I will, of course, give way.
When she appeared before us in May at the Home Affairs Select Committee, she claimed she hadn't had time to look at these cases because there had only been 2 working days before the issue was flagged up. She was told in November last year by an honourable friend of mine for Birmingham Yardley, a member for Reading West wrote to her in February. We've heard the member for Oxford East wrote to her in March. Can she clarify for the House today, and indeed other members of the committee, when she first knew about this issue?
So I think it's very important that we reflect that I can't comment on correspondence received by my predecessors back in November. What I think is important is that we are looking at the review now, the individual cases, of which there are many, and I will come to the specific points about numbers in due course. As the honourable members will know, the government is committed to building an immigration system which is fair to British citizens and to legitimate migrants, while being tough on those who abuse the system or flout the law. We welcome those who wish to come here, stay here, and take up highly skilled work. But people must play by the rules. Reports have suggested, and we've heard it repeated today, that the Home Office has been telling people who made a minor mistake on their tax records that we're deporting them because they're a threat to national security. I want to be very clear. That is not what is happening. We are not refusing people for making minor tax errors, and we are certainly not saying that they are terrorists. The visas that we are discussing today all relate to the Tier 1 general route, which allowed individuals to come to the UK to look for work without needing a sponsoring employer. The hope was that they would make a significant economic contribution to the UK through taking up highly skilled jobs. The government closed this route in 2011 as it had not worked as intended, and indeed there were levels of abuse. Many applicants ended up in relatively low-paid work, and an operational assessment of the route in 2010 found that 29% of Tier 1 migrants were in low-skilled jobs, and the employment of a further 46% was unclear. When they applied to extend their stay, many had PAYE earnings that were below what they needed to score enough points to remain in the route, but they also claimed for self-employed earnings. In some cases, the evidence showed that the claimed self-employment did not happen, and in other cases, the evidence was less clear. We were unable at that time to carry out the same level of checks with HMRC that we can today, and applicants in those cases where the evidence was not clear were given the benefit of the doubt. Now that those same individuals are applying for settlement, we are able to make more rigorous checks with HMRC on what applicants have told us in the past about their self-employment and compare it with what they have told us for HMRC purposes. Again, I want to be really clear. We do not have a policy of refusing people for making minor tax errors, and we all know that many people have to make corrections to their tax records. But there is a clear pattern which does not reflect the sort of minor corrections. In many cases, more often than not, the self-employed earnings used to claim points in the Tier 1 application have been £10,000 or more higher than the self-employed earnings reported to HMRC. That's not minor. And there are numerous examples where applicants have either not amended their tax records or amended them several years later and only shortly before applying for settlement, so that the records match. We have even seen cases where applicants have subsequently amended their tax records back down again after applying for settlement. We do give applicants the opportunity to explain, and we take their explanation and all available evidence into account. Any such cases must be signed off by a manager before they are refused. The review that I am carrying out is checking these safeguards to make sure that they have been followed correctly. We only refuse cases where applicants have been unable to provide a satisfactory explanation of what their self-employed activities are or why their earnings reported to the Home Office and to HMRC are so different. And we will refuse cases where the evidence leads us to conclude that an applicant provided misleading information to one branch of government or other. Which is what, I'm sorry, I've only got very few minutes, and that I want to explain what paragraph 3225 is for. Refusing applications where the evidence shows that an individual has not played by the rules. And whilst there has been focus on the minority of judgments which go against the Home Office, more often than not, the courts have supported our refusal decisions. I'm sorry, I just simply don't have time. I've got about 3 minutes left. To pick one example from May this year, the upper tribunal agreed with us that an applicant's explanation was simply hopeless, and the tribunal noted the timing of the amendment in relation to the ILR application. Paragraph 3225 is a very long-standing provision within the immigration rules, dating back to 1994. It was not introduced to support, I've already indicated to the Honourable Lady that I won't, and was not introduced to support compliant environment policies, as has been suggested, long pre-existing those policies. It does not mean that any particular individual represents a threat to national security, but for obvious reasons, we don't seek to isolate national security refusals from others. But I also recognise that it is not enough to simply talk about circumstances that happen more often than not. Each case is individual and must be treated on its own merits, which is why we're using this review to make sure that no one who has made an innocent mistake has been caught up in wider abuse, which is why we have had this review, which is still ongoing. The first phase is complete, and I just wanted to indicate specific numbers. There were 281 in the first phase and 1,671 in the second. Whilst I don't wish to prejudge the final conclusions, it has been very clear that they are broadly in line with what I have said this afternoon, and I will report the conclusions of the review to Parliament once it is completed. There was a very specific case about judicial review. Well, the first phase of the review, as I indicated, is already complete, and as soon as the second phase, which is a significantly higher number, is done, we will be reporting it to Parliament and to HASC, as I indicated. We are aware of 427 appeals and judicial reviews in progress. Many are still outstanding, but no applicants have been successful at judicial review, and only 38 appeals have been allowed, most on human rights ground. All current cases are on hold,
And while it is the case that applicants' statuses are protected, it means those who have applied before their existing leave expired can continue to work, and their other rights to rent and to NHS services are also unaffected. In 50 of the cases we have considered, there has been a discrepancy in